Oh my God, I have been very busy in Nicole Kidman and Keith Urban land, but there's a lot to catch up on here. Hello, my fam. It is Perez, the queen of all media, the original influencer, her number one source for everything It Ends With Us saga, and tomorrow they're going into a hearing. And if you want, you can listen in. This hearing is about his motion for judgment on the pleadings. Remember that explosive filing from last Friday night. To sum it up in like 20 seconds, Baldoni and the Wayfarer parties argued that the docket doxer's pleadings were not legally sound. Period. Therefore, they should be thrown away. Similar to a motion to dismiss. Well, understandably, parasite Patty over here was not happy about that. She filed a letter to the court asking her bestie, Judge Lyman, to deny their motion, or at the very least, let them have a lot of extra time to respond. We covered that already. You can watch that video if you want to be fully caught up. Well, her lapdog gave Baldoni and crew until today to respond to her objection, and they did, and we'll get to that. But first, I'm absolutely going to be calling in tomorrow. Oh, shoot, I can't. Fudge. I'm going to be busy. Fudge. I just realized the time. You know where I'm going to be at tomorrow? The ACLU of Nevada's luncheon, their big fundraising event that I am so thrilled to show up at and support, because were it not for the ACLU of Nevada, Litigious Lively and I would still be battling out in court. But I'll let you know of any developments that happen at the hearing tomorrow. If you can make it, it is on Friday, October the 3rd at 2 p.m. Pacific. You can join by teleconference dialing 855-244-8681. That's 855-244-8681. After you call in, you have to enter the access code, which is 230-251-28756. That's 230-251-28756. There have not been that many hearings in this saga yet, so I wish I could call, but I'm sure it'll be eventful. And I love listening to Lyman and the lawyers. And they made a lot of sound arguments, which Team Ridicula was trying to poo on and misrepresenting the law like they are prone to do. But Baldoni and crew were having none of that, and in their letter filed to the judge today, they say the following. Dear Judge Lyman, as counsel for Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sorowitz, It Ends With Us Movie LLC, Melissa Nathan, The Agency Group LLC, and Jennifer Abel, collectively the Wayfarer parties, we write in response to the letters dated September 30th, 2025 from Blake Lively concerning the Wayfarer parties' motion for judgment on the pleadings, the motion, and the deadline for service of requests to admit. This is actually a 2-in-1 letter to the judge. We're covering a lot of ground today. First, they argue the motion for judgment on the pleadings is timely. Rule 12C permits a party to move for judgment on the pleadings after the pleadings are closed, but early enough not to delay trial. Pursuant to Rule 12H2, a challenge to a plaintiff's failure to state a claim is not waived until the close of trial. Miss Lively erroneously argues that the Wayfarer parties sat on their motion for nearly 9 months, and that adjudicating the motion now would only lead to duplicative briefing and waste judicial resources. First, Miss Lively's operative pleading, her second amended complaint, was not filed 9 months ago, but 2 months ago. In response to the court's dismissal of her claims against Jed Wallace and Street Relations, Inc., Miss Lively was not obligated to amend her pleadings, but nonetheless chose, italicized, to file her second amended complaint on July 30th, 2025. When Miss Lively opted to supersede her earlier pleadings with this filing of the second amended complaint on July 30th, 2025, she knew the Wayfarer parties were not obligated to file answers thereto for several weeks thereafter, and that upon such filing, and only upon such filing, the Wayfarer parties were entitled to move for a judgment on her pleadings. Indeed, as Miss Lively recognizes, at a July 30th, 2025 hearing in a related proceeding, the Wayfarer parties notified the court that they may seek relief under Rule 12c. If Miss Lively is now unprepared to oppose the motion, the fault lies with her. Second, the motion will reduce briefing on any subsequent dispositive motion and preserve judicial resources. In contending that the question at this stage of the case is not what pleadings allege, but what the evidence shows, Miss Lively misconstrues. Kevin Fritz is being very polite. It's not misconstruing, it's misrepresenting what they do. Miss Lively misconstrues the standard of review on a Rule 12c motion. A judgment on the pleadings is appropriate where, with all reasonable inferences drawn in favor of the non-moving party, the non-moving party has failed to allege facts that would give rise to a plausible claim or defense. Here, the motion seeks dismissal based on purely or predominantly legal issues, meaning no evidence has to even be considered. 1. Miss Lively's claims for sexual harassment, retaliation, failure to supervise, and aiding and abetting under California statutes fail for lack of extraterritorial application. All the California brouhaha does not apply in federal court and in New York. 2. Miss Lively failed to exhaust her administrative remedies with respect to various claims against It Ends With Us movie. 3. Miss Lively failed to adequately allege retaliation. 4. Miss Lively's defamation claims are barred by the litigation and or fair reporting privileges. And 5. Miss Lively failed to allege an underlying tort supporting her civil conspiracy claim. That was a very brief way to summarize everything that we talked about late last Friday. Remember? I was so tired, y'all. None of those issues require the court to examine anything other than Miss Lively's second amended complaint and the materials incorporated therein by reference or integral thereto. Tellingly, Miss Lively does not specify how any of the voluminous evidence she has uncovered would be properly considered in opposition to the motion or warrant the denial thereof. Stated differently, there is no need for Miss Lively to scramble to amass evidence, as she claimed, from ongoing discovery to oppose the motion, because the motion challenges defects on the face of her own pleadings. Boom. Full stop. Just on the pleadings. No evidence. Alleged evidence. I'm still not convinced she's got any. Although Miss Lively notes that she may yet again amend her pleadings, she does not explain why she has not done so or why the court should allow any such amendment at this stage of the litigation. If the motion is granted in full or in part, any such adjudication will reduce the number of Miss Lively's claims. Yes! Let her just keep the SH one, because she's not going to be able to prove that. The legal bar to prove SH is high. It's not just hurt feelings. In turn, and even assuming any party subsequently seeks summary judgment, meaning they may not. If it's down to just the SH claims, they want to go to trial with that. But in turn, and even assuming any party subsequently seeks summary judgment, the case will have been properly streamlined, thereby reducing the amount of briefing and evidentiary submissions on any such motion. Thus, judicial resources will be preserved, the very purpose of a Rule 12c motion. Third, Miss Lively does not and cannot explain how the adjudication of the motion will delay the trial scheduled to commence on March 9th, 2026. Fact discovery is ongoing. No summary judgment motions have been filed, and the trial is more than 5 months away. Courts have granted Rule 12c motions at procedural stages that are much more advanced than in this case. In the alternative to her request for dismissal of the motion, Ms. Lively asks for an extension of time from October 10th, 2025 to October 27th, 2025 to formally oppose the motion. Ms. Lively seeks the extension for the reasons given above, which appears to be that discovery is ongoing. The court may recall that while discovery was ongoing, the Wayfarer parties were compelled to oppose dispositive motions as well as numerous motions for sanctions. 47.1, PTSD. The Wayfarer parties and their counsel, against the Wayfarer parties and their counsel, filed by Miss Lively and her husband, Ryan Reynolds. Additionally, granting Miss Lively's request would mean that the parties would be briefing the motion close in time to the summary judgment deadline before the court has had a chance to narrow the case. The request should be denied. Also, they're asking the court to amend the case management plan and scheduling order. They say good cause exists to amend the scheduling order. The proposed schedule, which they included to push everything back, will provide the court with sufficient time to resolve the motion, give the parties the opportunity to finish fact discovery prior to exchanging opening expert reports, and allow the parties to complete expert discovery prior to the filing of summary judgment motions. Most importantly, if the majority of Miss Lively's claims are dismissed via the motion, the proposed schedule will allow the parties and the court to focus on her few remaining claims in connection with any summary judgment motions and or trial. Moreover, on September 30th, 2025, merely 10 days before the current October 10th, 2025 deadline for opening expert reports, Miss Lively proffered a new theory of damages. Whereas Miss Lively's alleged lost profits computation was purely based on redacted, she has recently added redacted. The Wayfarer party's expert must now examine that claim. Wrapping things up, on February 3rd, 2025, the court directed in the case management plan and scheduling order that requests to admit shall be served by August 14th, 2025. In the parties' joint request to revise part of the scheduling order, no request was made to extend that deadline. This part's boring for me. And no extension was ordered. Now 8 months after learning the deadline. All right. the request to admit, yeah, exhausting, right? But I am committed to remaining your number one source for everything. It ends with us saga. Thank you so much for watching and sticking around until the end. You are the 1%. If you can, please consider signing up for my Patreon. You'll get an exclusive podcast a week from me, and I'm very active on the message board. Sign up right now at patreon.com/my name, P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. Also get a personalized video from me on the Cameo website. I've got thousands of glowing reviews, and I love making them. Book one right now at cameo.com/P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. And finally, get some of my Team Truth or buy some of my Grab Your Friends, Wear Your Florals merch. All available at my official merch store at buypopstuff.com. That's buypopstuff.com. And if you watched until right now, till the very end, you are the 1%. You are my VIP. Thank you, thank you, thank you. Watching all the way through your favorite creators' videos is the most meaningful way to support. Say support in the comments section and thoughts on everything. And will you be calling in tomorrow? Everybody should call in tomorrow and let me know what happens on this video. Let us all know together. Let us be all each other's reporters. I will be tuning in to the comments section here tomorrow to hear from you all. Thoughts on all the developments. Say support down below. I love you. I will see you later.